As we all know, during his first week in office, President Trump issued an executive order essentially trying to limit birthright citizenship. That limitation would essentially exclude anybody who was born in the United States whose at least one parent was a permanent resident or U.S. citizen at their time of their birth from getting automatic birthright citizenship. Now, here's the thing. We know that this is a constitutionally protected right. This is part of the 14th Amendment of the Constitution, which essentially states that anybody born in the United States is a natural-born U.S. citizen. And then about 20 years later, 30 years later, the case was heard in the Supreme Court, right? The Supreme Court had to make a decision about what does, natural-born citizenship mean. And in this matter, a Chinese immigrant whose parents were essentially not able to obtain citizenship because of racist immigration laws at that time, who was born in the United States, left and then re-entered, and they didn't allow him back in, saying, you're not a U.S. citizen. And the Supreme Court held that anybody born on U.S. soil, regardless of their parents' citizenship, is a U.S. citizen, with the exception of children of foreign diplomats, or, of course, if we were being invaded by enemy soldiers, then their children wouldn't be U.S. citizens. So now we're revisiting this issue. The Supreme Court has decided to hear the case. The Trump administration has filed an emergency appeal, and the Supreme Court in a few weeks will be hearing the matter of birthright citizenship. And so what are the options? What could happen? The only route they could take in terms of limiting birthright citizenship would be overturning precedent, that 1898 case, right? And saying, actually, the way that we interpret the 14th Amendment that says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And so, subject to the jurisdiction thereof is the clause that will likely be examined. Now, Trump's executive order, like I said, was attempting to limit birthright citizenship to only individuals born in the United States when at least one of his or her parents is a U.S. citizen or permanent resident. What this means is that people here on visas, although lawfully, who have children, their children would not be considered U.S. citizens at birth. So this isn't only attacking undocumented immigrants and their children. This is essentially saying if you don't have some type of permanent lawful status in the United States, your children cannot be natural-born citizens. It'll be interesting to see what the Supreme Court does here. This is a majority conservative Supreme Court. We really hope that they don't overturn long-established precedent, but we know that having long-established precedent doesn't necessarily mean that the Supreme Court is going to respect it, and that this Supreme Court is not scared of overturning precedent. On the other hand, we also know that the Supreme Court has at least recently been distancing itself from the Trump administration, has been willing to go against the Trump administration. So while we were very concerned that a lot of these justices are Trump appointees and that they were going to automatically side with Trump, I've been pleasantly surprised recently in seeing justices break with the Trump administration. So, this is obviously has huge effects on everyone in the United States, but for us as immigration attorneys in particular. Now, it would not be retroactive, it would be prospective. If it does, happen and it does get, limited. I hope that the Supreme Court will not overturn its precedent, but it will be interesting to watch and see.